From the Library of Congress in Washington, D.C.
So we're going to get started with the final session, and so just a couple of little housekeeping things. One, we want to have the opportunity, since everyone obviously wasn't able to sign up for panels. We tried to keep the panels very varied, and we actually had a number of people on them, but we obviously weren't able to accommodate everybody who signed up. So we wanted to give people in the audience an opportunity to make remarks if they hadn't already done so, and then we wanted to hear from anybody else who had any kind of final remarks. As I mentioned before, we're going to limit those remarks to just 2 minutes because we only have an hour, and we want to make sure that we do hear from everyone. And the way we will progress, we have a few, actually just a few, names of people who have signed up to kind of make remarks. We again are going to try to keep it to 2 minutes, so we'll have somebody who will hold up a sign at the 1 minute, 30 seconds, 10 seconds, and wrap time frame. If after we have the people who have signed up, and we have more time after that, then we'll open it up to people who can just kind of line up and also give final remarks as well. So in terms of the people who've signed up so far, and actually I think most of them are people who have the opportunity to participate, but since other non-participants haven't signed up, I'll just go through the list of people who've signed. Lisa Shaftel from the Graphics Article. Yeah.
Thank you for this opportunity to open this up to us. I have two things I want to address. The first one is there was a lot of discussion about public good, public interest, public benefit. I'm not an attorney. I read a lot. I've certainly read fair use a whole lot. I'm not hearing anyone discuss the rights of authors and creators and our economic rights in discussing the public interest. And the second thing I wanted to address was to Greg Cram and the other museum and library folks who put up exhibits of old work. I've done a lot of this sort of exhibit design with history museums. And without going into the personal stories, the historians that I've worked with have told me that they've never once been sued by a rights holder. On rare occasions, a rights holder comes forward. They set aside a certain amount of money to pay fees, and they do negotiate fees. And usually the rights holders who come forward have even more information about that historical event to contribute, and they identify more work. So my question is, you mentioned $1 billion plus. Jeff Cunard has said to me $30,000. Have any of you actually ever been sued by a rights holder?
Thank you.
So this is just speculation of fear.
Yeah, and I think one of the questions we have tried to explore is that speculation of fear or chilling effect in some way affecting the people's ability to actually make those works available. I'll go to Jean Dryden of the Society of American Archivists next.
Yeah, that's a very nice segue. My academic research has looked at the copyright practices of American archivists and Canadian archivists as well when they're digitizing their holdings and putting them online. And I've discovered they want to do the right thing. They're very risk averse. They're probably more cautious than they need to be, and they're sticking to the public domain stuff and the stuff in which they own the copyright. So that's easy. That's the slim pickings, the low-hanging fruit. Eventually, they're going to run out of public domain stuff and stuff they own. Also, user demand is demanding more recent stuff. And also, the whole idea of, instead of items, whole collections is becoming far more important. And yes, every work has a mummy and a daddy, but we can't find the mummy and the daddy because they're ordinary citizens that wrote to governments, to universities, or family papers. Searches for owners have been costly and often futile, and when located, the few we can, they're thrilled, absolutely thrilled. They don't want money. Hey, we're on the internet. For archivists, the prospect of damages is scary and will chill digitization projects, I think. The prospect of licensing fees is unrealistic for inadequately resourced organizations, so I'm very happy to hear that ECL generally excludes unpublished stuff, which is most of our holdings. And as Mr. Perlman said, I gather he's tired of us whining about being poor. You don't get a pass just because you're poor. But archivists are always making hard choices. We never have enough money. So if the choice is don't digitize and don't put it online, I think we are doing a great disservice to our users, because many people believe that if it doesn't exist if it's not online. And I want to raise that issue of the public interest and the public good that is served by archives, to support all those good things like transparency and accountability, or even if you have an anniversary to celebrate. If stuff isn't there, you're going to be really ticked off and whining that nobody saved it. Well, it's archivists who do that. So thank you very much.
Thank you. Next we have John Sadowski from Wikimedia.
Hi. So first I want to say we're grateful for the opportunity to participate in these roundtables and give the unique viewpoint of the Wikimedia movement. So I have 2 points I want to briefly discuss based on discussions we've heard here in the last 2 days. First, I want to emphasize that we want any reforms to minimize burdens on our volunteers who contribute to our projects. And these range from high school students to preeminent scientists, to people from foreign countries, including developing countries. The amount of burden in any reform will affect how we're able to use these orphan works in the pursuit of our educational mission. Any reform that imposes large burdens, such as an escrow fee, or that doesn't limit or remove monetary remedies for nonprofit educational use, would likely prevent us from being able to use them all together. Secondly, we've heard a lot of discussion on fair use as a vehicle for orphan works reform, so I want to comment on that. Since our goal is to provide material that is freely available, the Wikimedia projects make very limited use of fair use. In fact, our internal criteria for non-free content are much stricter than the law would allow for. We only use works under fair use if no freely licensed equivalent could possibly be created. So, for example, we generally do not host non-free photographs of living persons or of existing buildings, because a free equivalent could be created by a volunteer taking a photograph themselves. So thus dealing with orphan works solely by expanding fair use is unlikely to allow us to benefit from these works. So thank you.
Thank you. And that actually was concluded the list of people who actually signed up. So if there are others who would like to speak briefly, please make your way to the microphone and you can speak. But you can just come up one after another. Thank you.
Hi, thank you. I hope you all had a productive day today. I'm sorry I couldn't be here, but I wanted to come back because something's been weighing on my mind. I think it's of utmost importance that we separate digitization out from orphan works. Digitization is about taking mass works, digitizing them, and making them available. Orphan works, on the other hand, are about copyright protected works for whom an owner is hard to find or cannot be found. The digitization issue can be dealt with through a takedown procedure that can be created so that, let's say you have a mass digitization of an archives. You put it up. If there was a takedown provision that could be added to the law, hopefully, to say, hey, we don't want that up there because it's ours and you didn't have it. That's one way of dealing with that on that area. But from a use perspective, for commercial or non-commercial usage of orphan works by a particular user, whether it's a filmmaker or a compilation or a magazine, what have you, we may need some guidance on what's a reasonable search. I mean, not we may need, we do need guidance on what's a reasonable search. And again, it's a different issue. So I'm hoping that we can address that moving forward. Thank you all very much.
Thank you.
Hi, this is Mike Furlough, and thank you again for having us today. I earlier today identified myself as the incoming director of Heidi Trust. My day job until May, when I actually assumed that role, is Associate Dean for Research at Penn State University Libraries. So I just wanted to address Lisa's question about special collections, digitization, museums, exhibits and being sued. And I oversee an active digitization program. I oversee a special collections library. And I would say, no, I don't know of many instances where, or any instances of where, someone has come along and sued because in that kind of educational context, work has been made accessible online. However, we are living in a climate that allows for a great deal of risk aversion. We have risk aversion being encouraged today, even with explicit threats of lawsuits against libraries. So I think we have to recognize that while we're becoming less risk averse around certain kinds of uses, we're still in a climate that where there are certain organizations that don't represent the parties that are usually at issue around Orphan Works, who are out there making threats. So that's all I have to say.
Thank you. I think somebody else wants to get them.
Hi, Jeff Sedlik from the Plus Coalition, and we are neutral on Orphan Works legislation. We just serve in an advisory and support capacity to our members who are museums or libraries or archives, creators, distributors of images, users of images. But we do hear from our members as to what their concerns are. Of course, on the museum and library and archive side, we hear that with respect to injunctive relief, which is what I'm going to talk about here, we hear significant concern about the liability posed if they move ahead with making use of an image in a book or in a display, and then injunctive relief comes along and they have to stop. How do they pull the books back, or what fees are they going to face in terms of reasonable compensation? It becomes a very difficult concern, and it almost obviates the benefit of having any Orphan Works legislation pass. But from the creator side, what we hear is they're afraid of three different issues. One is objectionable use, which is, let's say, competitive use. Photographer takes an image, somebody finds the image, and begins to use it on a poster or licenses, use it in some form of advertising, et cetera, some type of commercial use in competition with the creator. That is an issue. Usage for political or social causes that would not otherwise be allowed under fair use, and I won't get into that here, but let's just say using the photograph not to comment on the photograph, not to parody the photograph, but just in general, and the creator finds that particular use is objectionable, whether that is a cause that they don't agree with, et cetera. And then you have issues of violations of the whatever the new Orphan Works Amendment might be. Something like an insufficient diligent search might not carry a significant penalty, whereas a false diligent search should carry a very significant penalty. Issues such as claiming authorship or ownership of a work that they're using as an orphan work should carry a significant penalty. Failure to pay reasonable compensation, if reasonable compensation is defined, should carry a significant penalty. And there should not be any form of relicensing involved once you clear an orphan work to say, I've cleared this, now everybody can use this orphan work. That's what we hear from our members. Thank you very much.
Thank you.
So I'm Cram from the New York Public Library. One of the questions this morning in the first panel was about intent to use applications. And I wanted to highlight something in the Library of Congress's submissions on the Orphan Works issue. And they were talking about how they posted a number of images online and under unclear rights status. And they were able to get a number of helpful suggestions from the public about fixing their metadata. I think that's probably the better solution than requiring libraries and archives to submit to the Copyright Office or someone else a specific list of items they'd like to make available. And for us, we digitize a number of items every day. It would be really difficult for us to keep up with that amount of digitization if we were required to tell the Copyright Office or tell someone every day, this is what we're planning to digitize.
Thank you.
Just a quick comment, because it wasn't addressed earlier under remedies, but I think it's also worth looking at Section 506 and maybe defining that if someone has completed a due diligence search, that would exempt them from being found of a willful infringement. I think criminal penalties need to be looked at as well, because that's certainly a deterrent for something that could cross into that area even after a diligent search.
Thank you.
Sorry, Hope O'Keefe for the Library of Congress, correcting the record from my learned colleague here. The materials that the library had posted online were not subject to copyright. They were things that had no known copyright restrictions. Nevertheless, we put them out for tagging and crowdsourcing and have made 5,000 changes to our catalogs based on crowdsourcing, and we have corrected our metadata, and it is, as Barbara Natanson talked about yesterday, a terrific way of de-orphaning materials if we can find a way to do that.
Thank you. Do we have any other final remarks or comments before we close it? Yes.
This is Michael Capobianco of Science Fiction and Fantasy Writers of America. And I just wanted to emphasize that what we would like the Copyright Office to do, if the problem of Orphan Works is that the authors cannot be found, we would like the Copyright Office to work on ways to make authors findable. And that seems like a thing that's within the Copyright Office's purview, and it would be a lot easier than changing the law.
Yeah, and I certainly will say that we heard a lot about that today. We did have a one panel about registration and private registries and public registries and things to do to improve the registration system. But we also have actually a whole separate kind of initiative that the Copyright Office is undergoing right now to try to help improve the registration system, because that is something that obviously is a huge factor in this discussion. Are there?
Add something about that really quickly. For those of you who weren't here yesterday, part of that equation is the recordation system, and they're having roundtables later this month in California and New York. So it's on our website if you're interested in that issue.
Yeah, we encourage those who because I think recordation was also something that was mentioned. So if you have an interest, certainly please sign up to participate in those roundtables as well. Any other final comments before we close down our roundtables? All right. Well, we want to thank all of the participants, both the panel participants as well as the audience. You certainly gave us a huge amount of information and a lot of things to consider. We will parse through all of the information. As I said before, the actual roundtables have been videotaped, so they will be available on our website at some point. And we have given you also the opportunity, if there are issues, new issues that have been raised that you would like to respond to in writing, we are accepting additional written comments. We don't expect or necessarily want you to merely reiterate what you said in your first set of comments, but if there is something unique that was raised in the roundtables that you really want to respond to, please feel free to use that opportunity to file additional written comments. Thank you very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.